Good afternoon, everyone. My name is Alan King. I'm one of the wealth consultants here at LifeTime Asset Management, and I want to welcome you to our second episode in the Lifetime Learning Series webinars. Today, we're covering a critically important topic for everyone, estate planning, with our colleague, Christopher Morden, and we appreciate his time and expertise in sharing this with us. Before we get started, I just want to let you know that we do welcome your questions. If you have any questions now or during the presentation, please email them to info@lifetimeasset.com, and then we'll review the questions at the end of the presentation. We are recording this session, so you can rewatch it and share it with your friends and family. Stay tuned for details on that. Our speaker today is Christopher Morden. He's an estate planning and probate attorney with offices here in Raleigh and Wake Forest, North Carolina. He helps his clients with estate planning as well as estate, guardianship, and trust administration. And he can also assist with asset protection and various business and law matters. He's a partner at Monroe, Wallace, and Morden, and for multiple years in a row has been named to Super Lawyers Magazine's Rising Stars list, which is accomplished by no more than 2.5% of lawyers in North Carolina. He's also been listed by Business North Carolina's Legal Elite in the tax and estate planning category as among the best of North Carolina attorneys. He's a graduate of Campbell University School of Law, has his MBA from Campbell University, and a degree in economics from the University of Michigan. Without further ado, let's get started. Chris, thanks for being here today.
Thanks, Alan. Enjoy it.
Chris, in preparation for our conversation this afternoon, did a little research on estate planning and was surprised to discover that more than half of American adults don't have a will. Why do you think that might be?
Yeah, there are various studies that say usually oscillating around the 50% mark, 55% mark. And I read one time even that of the remaining people that do have estate planning documents, they are so out of date as to be ineffective. And so the article was really arguing that something around 70 to 75% of people have, really effectively no estate plan because they've got no documents, or their documents are so out of date as they don't really accomplish their objectives anymore. I think there's probably a host of reasons people kind of put it off. I mean, nobody likes discussing death or incapacity or illness or sort of contemplating those things and how they might, impact their lives. And a lot of people fear that, well, by having this power of attorney or something, I'm somehow giving up control, and my kids might be able to access my bank accounts or something along those lines. So I see a lot of this fear of control, and I mean, let's face it too. I mean, nobody really likes having to deal with lawyers, right? And so I'm certain there's that component of it as well.
Exactly. Well, I'm certain that you have a lot more great information to share with us and just get some basic knowledge and motivation for the rest of us to get those documents updated and get our plans together. So with that, I'll let you kind of take over, and then we'll have some questions at the end.
Okay. Well, Alan and I tried this earlier in the week, so I will share my screen and hopefully we can do this successfully. And then you guys can see this presentation. Let me see if we've got that.
That looks great.
It looks great. So you can see the whole thing.
Yeah, we see the PowerPoint.
Okay. I will turn it into slideshow mode, and hopefully that will clear it up. Okay. Now you see just the slides?
Yep, that looks great.
Great.
Thanks, Chris.
Well, I'll move you guys here so I'm looking at the slides and at everyone at the same time. Good. Well, thanks again for having me. I appreciate the opportunity. Obviously, disappointed it can't be in person this year, but happy to be a part of it nonetheless. And so I get a lot of questions from time to time really about when do I need to do estate planning versus when do I need to just have a will? And to me, I mean, a will is just one piece of an estate plan. And kind of from this slide, we'll talk a little bit about that. Because when I tend to think about estate planning, I sort of divide it up into two basically broad categories, right? One category would be planning for incapacity. So I think something's happened to me and I'm still alive, but for whatever reason, I cannot make or communicate a choice. So I want to have documents in place so that way someone can step in and have the authority to pick that up and go with it and keep my bills paid or talk with my doctors and make those healthcare decisions on my behalf. So therefore, the incapacity side of things, we'll generally use a financial power of attorney, someone or really a series of people that are there ready to take the reins and manage my finances for me. And then healthcare power of attorney, living will, those are documents that allow you to determine who are going to be your healthcare agents to step in and start making healthcare decisions for you. And the living will is really your direction to your doctor about what kind of treatment options you may want in certain end-of-life scenarios. And then trusts play a role in incapacity planning as well, because if I created a trust, I could then transfer kind of all my assets into it if I choose to. And so at my incapacity, my successor trustee just sort of takes over. And then those assets are already in the trust. And so my financial power of attorney doesn't really come into play then because I don't own those assets as an individual. The financial power of attorney is naming a person that steps in and can take control of your individual assets or manage your individual assets for you. And the important thing of this incapacity planning piece is really us getting this order of agents there so that way these people are ready for when a situation arises, and it allows us, most importantly, to avoid having to go to court and getting a guardian appointed for you. So nobody wants to go through that process. To the extent you can avoid it, it would be all the better for it. So that's sort of one piece of estate planning, this incapacity planning. And then the other kind of more traditional planning or more traditional piece that everyone thinks about is, well, what's going to happen with my assets at the time of my death? And this is where I kind of mentioned early on that a will is just sort of one piece of the puzzle. As we look at a few more slides in, we'll talk about kind of the importance of how assets pass. And you'll see that assets passing under a will is just one option. So the important thing to think about when you're looking at how assets pass at death is certainly be reviewing those beneficiary designations and just how the assets are owned. Is it an asset that you own individually, or do you own it joint with right of survivorship with a spouse or a child? And then again, trust. Assets owned by the trust. At my death, my trust just says, okay, when Chris dies, these trust assets are now to X, Y, and Z is supposed to happen to them. So a trust, again, is just another tool that can be used. We don't use trusts in every estate plan. It certainly has its time and place, but I don't think it's necessarily needed for everyone. So then back to the first piece, the incapacity planning, the financial power of attorney. Just like I talked about, you're able to name in there really what I push clients for is naming a series of agents. I really push hard for us to have at least a primary person and a backup person. Kind of the more the merrier, but I really like for there to be at least 2 levels deep on these roles. But we want this financial agent so that way they can then step in and pick up and manage your finances on your behalf. The healthcare power of attorney, this is I also alluded to, you name again a series of healthcare agents to be there so that way if a doctor determines that you can no longer make or communicate a healthcare choice, that will trigger the healthcare power of attorney to turn on, and then that agent that you have designated will then have the power to step in and start making those healthcare choices for you. And the living will, here at our firm, I generally will combine the healthcare power of attorney and living will into one form, just because I think it reads a little more cleanly. and it's easier to kind of lay out who has the decision to be made or the decision-making authority in the end-of-life scenarios that are laid out in the document. But I know a lot of attorneys that still separate them out into you have a healthcare power of attorney, and then you have a separate living will. However, you and your attorney have done it. I really encourage clients when they're done with the healthcare power of attorney to send that off to our North Carolina Secretary of State. The North Carolina Secretary of State has this database that you can put your healthcare power of attorney into, and then you get a database card that I just keep my card in my wallet right behind my driver's license. And that card basically has on it a username and password. So if I'm injured on my way to work and go into the emergency room, hopefully I can either show them the card or the card is found in my wallet because it's with my health insurance information and my driver's license. And then they'll be able to download my healthcare power of attorney, see my wife's contact information on there, and then call her in the event of emergency. So I think that really worthwhile. And I sort of touched on how the trust are built into that as well. So, what is a trust? It's really just an agreement where I, as the person creating the trust, might leave assets to the trust, and maybe Alan is my trustee. And so then I am putting my assets into the trust, and then Alan as the trustee, he is the one that's managing those. And generally how we word them is, if I'm the person creating the trust for my estate planning, I am also the trustee. So I'm putting the assets in there. I still get to control them however I want, spend them whatever I want. But it's just the trusts are already in the assets are already in the trust at my death, or in there during my lifetime. So at my death, they just sort of continue on, and then the next trustee will pick it up. Or as we're still sort of in this incapacity planning part of the presentation, if I have my assets in my trust and become incapacitated, then my successor trustee just takes over the trust and the assets that are already in there. So it kind of provides for a seamless transition from me to the next person that I designate to control them for me. So planning for assets and how they pass at death. And so I talked about kind of the ways that assets will pass. And so this is very important to think about when you're doing your estate planning, because assets will only pass one of three ways at death. And the first way would be by beneficiary designation. So your life insurance policy or IRA or 401k, you're able to designate on there a primary beneficiary and a secondary beneficiary. And that beneficiary designation is basically a contract between you and, say, the life insurance plan provider. So at your death, that life insurance company is obligated to pay out that policy based on what you've listed in the beneficiary designation. So I might say in my beneficiary designation, I leave my life insurance policy to my wife, but in my will, I might say I leave that same life insurance policy to XYZ charity. Well, at my death, that beneficiary designation is going to be what controls, and so it goes to my wife, and the charity is just sort of out of luck because that provision in the will is meaningless when you've got the beneficiary designation. So when you're doing estate planning, whatever plan it is you're going to put in place, you want to make sure all these things line up, because having the assets pass based on the beneficiary designation is generally going to be a better result because it keeps those assets out of your probate estate. So your executor doesn't have to worry about them. They just pass straight to whomever you've said they pass to. And it allows you to avoid kind of the time and the probate cost with the clerk of court. So beneficiary designations is something that we really push hard on clients to make sure that they've got that lined up appropriately. That's why it's great to have Alan and the others at LifeTime on the other side helping the clients, because I know when I've got my plan done, I can just email Alan and say, okay, look, I've got this done. I now need you to change the beneficiaries to, whatever I say. and then they make sure that happens. That way, my plan is able to be seen through efficiently as possible. Next way that assets would pass would be by their ownership characteristics. So there, examples of this are joint bank accounts. So if Alan and I have a joint bank account, well, at my death, he is the surviving account holder, so he just gets that whole account. Again, it doesn't matter what my will says, that's the way that account is set up. Same thing would hold true for a POD or TOD. POD meaning pay on death, which is something that you could put on your cash accounts, like a checking account or money market account, savings account, things like that at the bank. You can say, well, I want to continue to own this account for the rest of my life, but I want my children to be the POD beneficiaries. And then the bank will give you that documentation. You can make sure that the kids are listed in there, or spouse if it's an individual account, whatever you want to do. So POD is for cash accounts. TOD is for stock accounts, transfer on death, because you're having that stock transfer to whoever you named as beneficiary. And then another great example is tenancy by the entireties. Tenancy by the entireties is a method that a married couple can own real estate in North Carolina. Not all states have tenancy by the entireties. Kind of a fair amount do. It's less than half, but it's North Carolina is by no means the only one. But what it means is, so my wife and I, we bought our home during our marriage, and so the default classification for a married couple buying real estate in North Carolina is tenancy by the entireties. What it basically means is the marriage entity owns the property. And that is excellent for us from an estate planning perspective, because then I know at the first spouse's death, that home just automatically becomes owned by the surviving spouse. You don't have to do a new deed. It just happens instantaneously by operation of law. It's also important because it gives us a easy, strong level of creditor protection. So if I'm out driving around in my car this afternoon and run into Alan, say, he's going to sue me because I hit him, and if he gets a judgment against me, he cannot attach his judgment to my house because I don't technically own the house at this point. It's the marriage entity that owns the house. So it's a way for there to be a good level of creditor protection. Doesn't hold true to all creditors. I mean, as you might imagine, the IRS can, if I had a tax lien against me, the IRS is sort of a super creditor, so the IRS can get through that. But for running into Alan with my car, he could not attach to my real estate. And then final way that assets pass will be under my will. So really the assets that are left that don't fit under those first two categories would fall under the terms of my will. And that's really because the first two categories allow for those assets to just sort of pass automatically at my death. With the life insurance policy, my wife or my children would just give my death certificate to the life insurance company and then have to fill out their paperwork, but then they would be able to get a check from the life insurance company. Or the joint account, the example that I gave with Alan and I having a joint account, he would just take my death certificate to the bank and that account becomes his. But other assets that are left that don't fit into that beneficiary designation or ownership characteristics, those would be governed by the terms of the will. So examples there are, let's say I have a small business interest. Those generally, no one has done kind of a beneficiary designation on there. And so that would be a personal property interest that would flow under the terms of my estate, and the will would say where that goes. Or, it's always the stuff around my house, my clothing, jewelry, furniture, china, antiques, collectibles, stuff like that. My vehicle. Those are all kind of examples of things that don't have a designated beneficiary on them, so they would flow under the terms of the will, unless you kind of do something otherwise. And so, at the end of the day, the estate planning is kind of making sure all of these things get into a line, so that way everything goes where we want it to go. You don't want to kind of go through this whole process and then miss a beneficiary designation on a life insurance account or something like that. That would be difficult, problematic. All right, so the will I talked about manages your probate estate. So just what is the probate estate? Well, like I mentioned, it's really the assets that are left that are in my name that don't have any type of identified beneficiary on them. So let's look at kind of an example of how this might play out. So here we've got husband up in the top left that owns those various assets. In our example, the husband is going to pass first and leave assets to the wife. This just kind of happens to be the example that we've given. I could think about it as if I was the last spouse, then maybe I'm still the husband square, but it's really just me as an individual, and then my children are down kind of in the wife square. The result kind of plays out the same. So the husband has the car, some personal property, some stocks, other bank accounts that are individually owned, some joint accounts, retirement accounts, life insurance, and real estate. So how do these things get to the wife? So automobile, as I mentioned, doesn't have a designated beneficiary on it, so it goes into the probate estate. Same with personal property. Now these stocks that are individually owned, in our example, we're just kind of saying here that the husband failed to put on there a transfer on death beneficiary, so those are going into the probate estate. The same thing with his individual accounts. He failed to put a POD on them, so those go into the probate estate. But then the accounts that he held with wife that were joint with right of survivorship, or that just named the wife as the POD beneficiary, those go straight down to her. So we've avoided the probate estate with those. Same thing with retirement accounts. He's named his wife as the beneficiary, so those go straight to her, avoiding the probate estate. And same for life insurance. And then that real estate that I mentioned, that's owned tenancy by the entirety, so that will go into or straight to the wife. So then what happens? So the wife's got some of the assets, but she doesn't have them all. The probate estate has got the other ones. Well, we've got to get them out of the probate estate and down to the wife. So we think about how should we get this handled, and there are some ways that you can kind of streamline the process. Most of the time we see the only probate asset is really just an automobile, because the one spouse owns their own automobile, and then the other spouse owns their own automobile, and the rest of their assets are kind of jointly owned or have each other designated on there. So most of the time we see just kind of an automobile, and there's a year's allowance, which is kind of an easy court form to file that allows the surviving spouse to get that vehicle and any other probate assets that might be left in there out right away, as long as those assets all combined total less than $60,000. That year's allowance is a pretty easy way to do that. So probate process, you're going to have to pay the deceased spouse's final debts, final income taxes, court fees, and then once that's done, the estate makes the distribution down to the wife of all those probate assets, and so then the wife has everything at that point. So that's kind of a quick example of how we got that through. Alan, want to save some time for questions. I recognize that we've only got a half an hour here, so I'll talk about a couple of hypotheticals, and then if you've got some questions that someone has emailed in, be happy to answer those as well.
Chris,
Yeah.
we have a full hour, so take your time. And
oh, we have a full hour. Okay, great.
Yep. Yeah, sorry about that.
So the hypothetical one, so we've got A and B, Adam and Betty, have two minor children. C and D, Charles and Deborah. Adam and Betty own a home, various bank accounts, life insurance, and retirement accounts. And so we've got to think about how are we going to plan this out? And really here where the problem comes in is the minor children, because the minor children cannot inherit assets, or at least because they're under age 18, they cannot receive them. So a guardian would have to get appointed to receive them. And then when the children reach age 18, they would age out of the guardianship, and the guardian would turn that over. So that's kind of a problem. So what we do in this type of situation most commonly would be to have the plan set up where at the first spouse's death, everything goes to the surviving spouse. And then at the surviving spouse's death, we really want everything to go down to the kids, but the kids are too young and can't receive it. So instead of sending it to the kids, what we do is we send it to a children's trust, a trust for the benefit of these children. And so what happens then is the children's trust receives these assets in, and it functions as like the shell that owns these assets. And the clients, Adam and Betty, would name a trustee of this trust, and then that trustee would manage those assets for the benefit of the kids. Usually what we would do there is say to the trustee, okay, this money is in there. It is to be used for Adam and Betty's children until they kind of phase out or age out of the trust. But while the money is sitting in that trust, it's still available for the kids, Charles and Deborah. So usually what we say is money can come out for the children's health, education, maintenance, or support. And obviously health and education, pretty straightforward. Most people know what that means. It's pretty easy to distinguish what is a health expense, what is an educational expense. The other two, though, the maintenance and support, invite a little bit of gray area, but how I typically explain it to the clients is it's designed to keep the trust beneficiaries in the lifestyle in kind of which they're accustomed to living. So let's say one of the kids, Charles, is driving around in a Toyota Camry and that thing blows up and he needs a new vehicle. Well, the trust can buy him a new vehicle, but the trust cannot buy him a Ferrari because it has the money to. The trust could buy him another Toyota Camry or equivalent. As I said, the trust keeps them at that level of which they're accustomed to living. It's there so it can provide for them so their lifestyle doesn't go down, but it's not there to elevate their lifestyle either. It's to kind of to keep all things being equal. Now, if Charles, in our example, goes out and gets a really good job and he elevates his own standard of living, then great. And the trust can kind of rise up to meet that. But it's always just going to kind of keep him level with where he's at. But then we need to think about, well, we probably don't want this trust to exist for the benefit of the kids forever. So we need to think about what age, or really better yet, series of ages, should the trust gradually phase out and the assets become the children's. And I really like to have there kind of a series of ages where the trust might pay out to the kids. I generally don't start it any earlier than 25, but we might say half at 25, half at 30, or 25, 30, 35. It just kind of depends on the kids and their ages. My children are 10 and 6 and 1. And so it's difficult for me to know how financially responsible they are going to be when they become adults. Right now they would just blow it all on junk. And so, I might say now, well, half at 25, half at 30. But when it gets closer and, maybe one of them is reaching 25 and I realize that, hey, he's still not going to be financially responsible, then I can certainly revise the will to push that out. And I get those calls from time to time. We're going to go from 25 and 30, we're going to go to 35 and 40 kind of thing. And the will can always be modified, little things like that. And sometimes, it goes the other way too. We say, well, all the kids have graduated college now and they're in their early 20s to 30s and, I'm confident they can handle this. And so let's just do away with the trust. But when you plug in those ages, what I like to do is say, if we're saying half at 25, I would say, okay, when one of my kids, Charles or Deborah, I was picking on Charles earlier, so let's say Deborah. So Deborah, I like to say it so that way when Deborah reaches 25, she has the option to withdraw half. And when Deborah reaches 30, she has the option to withdraw the balance. I like to build in this option to the children rather than saying, okay, trustee, when Deborah reaches 25, you shall distribute half to her. And when she reaches 30, you shall distribute the balance to her. I like that option for the kids to have there because, sorry, my Amazon Echo had picked up, I guess, when I said Deborah or something. So it was trying to play some music. But I like to give the children this option of having this withdrawal, because I think about if I'm one of the trust beneficiaries and say I'm age 29 and I'm going through divorce, then I am not going to exercise my right of withdrawal. I'm going to wait for that divorce to finalize, and then I will exercise that right of withdrawal, because I don't want to invite the possibility of my divorcing spouse to come in and try to take half of this trust asset. Or maybe let's say one of the kids goes out and becomes a brain surgeon or is in some other type of risky profession. Well, if we do that, then my advice to the kids might be, well, the child might be, don't ever exercise your right of withdrawal. Just leave that money sitting in there, and it's always going to be available for your health, maintenance, education, and support. But while the money is sitting in that trust for you, it is as protected as we can make it. So it's not available to the child's creditors. So if Deborah is my brain surgeon and she commits medical malpractice giving me surgery, then if I sue her, I can't get to this trust that was created by her parents, Adam and Betty, because it's insulated for that. So the trust built in for the kids leaves a lot or establishes a lot of protection. It's a big benefit, but only if it's worded in such a way that it gives the child that option to take it out, rather than saying, okay, trustee, you shall distribute to them at age 25 and 30. And so we talked about, I sort of got ahead of myself in the slides here, concerns, naming appropriate individuals. Oh, yeah. So when you're naming the trust, obviously we've got to name some trustees. Again, here I really push clients to have at least 2 trustees named, because I want that primary person and the option to have a backup if needed. So you got to think about who are going to be the trustees. You got to follow through on beneficiary designations, which becomes very important. Because right now, in our example, Adam and Betty, commonly would come to see me and they would have their beneficiaries designated so that spouse is the primary beneficiary, and then they've just named the children as the secondary beneficiary. Well, if they leave it that way, and we've got a trust that says, we've got a will that says all to spouse and then to the children's trust, but we've done a beneficiary designation that leaves it straight to the kids, then it's defeated that children's trust. So you've got to dial it back a level. So your beneficiary designation would become spouse first, because we're not talking about changing that. And then we would make the secondary beneficiary the children's trust. And let's say they signed their will today. So I would just name it the Children's Trust under will dated September 17th, 2020. And that would be how I would identify it in the beneficiary designation. And then keeping the plan updated as lives change. Everyone's going to have different things that come up. And I think about my own estate plan. It's probably, I did it shortly after my first child was born. So that was about 9 or 10 years ago now. And I think about, I've got my parents named in there, and my parents are now 10 years older since the first time I've done that. Are my parents still good options to have in some of the roles that I've named them in, or should I take my parents out and designate a sibling or something like that in one of those roles? My advice to clients is to be revisiting the documents every 3 to 5 years. 2020 is particularly a good year to be doing it because it's a leap year. So you could say, well, every leap year, I'm going to revisit my documents. And really what I mostly want the clients to be doing is pulling the documents out, looking at the various agents that they've named in the roles and making sure the agents are still good for those jobs. And then making sure this idea of the structure of how the assets pay out is still appropriate. So if for Adam and Betty in our hypothetical, we talked about a trust that paid out to the kids, half at 25, half at 30. Is that still appropriate ages, or do we need to adjust that in some way? That's kind of the things that I want clients looking at. They don't necessarily need to be coming back. I tell them, you don't need to come back to see me every 4 years, but just call me if something changes and we need to adjust the beneficiaries. If something happens from a legal standpoint, Congress changes the tax laws, or as what was done late last year with the Secure Act that passed, that kind of messed with how retirement accounts can get inherited. So, in those instances, if there's an issue that I foresee, we'll generally write to clients, or a lot of times clients are seeing their financial planners on kind of an annual basis. And so I see the financial planners for clients kind of bringing those issues up as well. So you can't just set it and forget it. It's like I mentioned to Ellen when I first jumped on the call, there's a high percentage of people that their estate plans are so out of date that they don't function effectively now anyways. All right, hypothetical 2. So husband and wife each have children from previous marriages. They maintain some individual assets and some joint assets. Each want to ensure their individual children are taken care of, but also want to ensure their surviving spouse is provided for during his or her lifetime. It's a pretty common example we see in second marriages, the second marriage situation. And so fortunately, though, all of those objectives can be accomplished through appropriate estate planning. Really what it comes down to is we need to think about what needs to happen at the first spouse's death. And kind of the important piece there is, back to the kind of the text of this hypothetical, we talked about, well, one of their goals is making sure that the children are taken care of, but also want to ensure that the surviving spouse is provided for. So, as far as providing for the surviving spouse, we could have at the first spouse's death, all the assets flow into a trust for the benefit of the surviving spouse. And we're going to put these restrictions that I talked about on how those assets are held. So we generally would say, well, the income from that trust must get paid out to the surviving spouse. Principal can go out to the surviving spouse for health, maintenance, education, and support. But those trust assets have to remain there for the benefit of the surviving spouse for the rest of their lifetime. And then at the death of that surviving spouse, then those assets go to the first deceased spouse's children. So it'd be a way for kind of me to protect my individual assets I had from possibility of my wife remarrying, or even from time to time we'll see maybe they won't remarry, but a caregiver or something might get in there and do some take some inappropriate actions with the surviving spouse as far as getting them to change their accounts and things. So the trust is a way for us to kind of lock those assets down. But also it's good to look at what is the kind of age difference between the spouses, because I think if I am 80 years old and I'm married to someone who's 40 years old, and I leave everything into a trust for the benefit of my surviving spouse, who's 40 years younger than me, say, then at my death, those assets will flow into the trust for the benefit of my younger spouse. But they sort of get locked in there for the benefit of only my surviving spouse for the rest of her lifetime. And so if she's 40 years younger than me, odds are she's going to live a longer period of time, may even outlive some or all of my children. So my children might not get anything. So in those types of instances, what we might think about is how do we get some money to the kids right away and then protect some money for the benefit of the remaining spouse. And so we might fund it through life insurance policies or have retirement accounts go to those children as well. You've got to be mindful of what type of assets you are sending to different people, because not all dollars in your estate plan are the same. So if I leave my child $1 of life insurance, well, then they're going to get the whole dollar. But if I leave my child $1 of my IRA, well, they're not going to get that whole dollar because that's got some income tax liability tied to it. So they might be getting 65 cents on the dollar. You just got to be mindful of what are the dollars in the estate plan and what do we need to trigger them to. And so that's why, as we're sort of at the end of this, but that's why when clients tell me that they might want to leave a charity something in their estate plan, then the first place I look is for qualified funds. Do we have IRAs or 401ks or something like that that has pre-tax dollars that will have some income tax liability to it? Because if I can leave that to the charity is going to get the whole dollar of that IRA because they're a tax-exempt organization, and the charities don't care what type of dollars they get; they're just happy to get your dollars. So if I can send the pre-tax dollars to the charity, then I can reserve the other dollars for the benefit of my family. And so really in those types of instances, everybody wins because the charity is happy because it's getting dollars, and the family is happy because it's getting dollars that are worth the whole dollar. So you gotta once you get your plan in place, you've got to be mindful of how are we going to fund it with these different things, and that's why I go back to the beneficiary designation. The beneficiary designation becomes critically important. A couple war stories here, since I guess I must have misread the email, Alan, so I didn't know that we had an hour, which is great. I appreciate the extra time. So I had an estate one time where beneficiary designation was not done properly. And so at the father's death, he had in his will a trust that was set up for his son, who was a minor, but failed to do his beneficiary designation. And thankfully, it wasn't an estate plan that I was a part of drafting. I was just sort of a part of fixing the issue. But what happened was the minor child, his biological mother, who is the deceased father's ex-wife, she was appointed as the guardian for the minor child, and she then took control of the deceased parents' life insurance dollars. So obviously the husband, the father, the ex-husband, would not have wanted his ex-wife to be in control of those dollars. But the trust that he had taken the time to have drafted in his will said that everything went to the child at age 25. Well, when the guardian took the money in, it was still brought in, and it was still used solely for the benefit of the minor child, which was all good. But when that minor child reached age 18, the guardian had to turn it over to the 18-year-old. And so I don't know many 18-year-olds that could necessarily do well with being handed $600,000 in cash, which is what we had to turn over to this 18-year-old. So fortunately, I was able to kind of sit him down and explain the situation and say, look, I can see what your dad intended to do here. It's just beneficiary designation was missed. And to that young man's credit, he agreed to turn the money back over into a trust that we kind of created for him to allow it to kind of be held in that trust structure until he reached age 25. It was a pretty easy sell because he was pretty responsible. So I was just sort of got lucky in that scenario that we're able to still accomplish Dad's objectives, even though there was a mistake that was made. So that kind of early on solidified the need in my mind to make sure that clients are following through on the beneficiary designations because it's so critical. So good. Are there any questions that people have raised, Alan, that you want me to address?
Yeah, Chris, we can't thank you enough for taking the time to kind of share your
You're
information and stories with us. It kind of on the surface seems like a relatively straightforward kind of thing, but it's always the devil's in the details.
Yeah.
But that's kind of one of the reasons that we started these particular webinars, is just to kind of enhance everybody's financial literacy and just kind of introduce them to these various topics, so they kind of have enough background to know what questions to ask, and that helps us from a financial planning perspective.
Sure.
And then when we send them to you to start building their estate plans. We do have a couple of questions, so let me kind of go to the list over here. Great question. I hadn't really thought about it much, but do estate planning documents that are written in North Carolina apply to other states? And the example is husband and wife live in North Carolina, but they buy property in another state. Do the North Carolina documents cover their property that's owned elsewhere?
Yeah, that's a good question. And so, I mean, the short answer is yes, it does. But kind of a better question to ask is, will it efficiently pass? Or can we do something to improve that? And so, for example, in Virginia, I know that if I have my North Carolina will and that will is probated here in North Carolina, I can just take a certified copy of my Wake County estate documents and send them up to the county that the property is located in Virginia, and that is sufficient to pass title on to whoever I say inherits that property in my will. So we get lucky in Virginia because we can just send that up there and then that's enough. Other states are not so lucky. So Florida is a good example of this. So what you have to do in Florida, if the property is still owned individually by the person, is you'll do your probate administration process here in North Carolina. And then what we'll unfortunately have to do is hire another attorney down in Florida to do it's called ancillary, to do an ancillary probate procedure down there. That way that probate process will pass the title on. So some states, we can get away with just having our North Carolina will and filing a copy of it there. Other states, you have to do an ancillary probate. The way I get around that commonly is if I know that that's going to be a situation, what I'll have clients do instead of just having a will is we'll set up a will, and then we'll set up a separate revocable trust or revocable living trust. They kind of have a lot of different names, but it's a trust where you set it up during your lifetime. You have the power to change it however and whenever you want, as long as you are living and competent to do so. And then what we do is once we get that set up, we have to get an attorney up in New York or Florida or wherever the state might be, to deed that property from you as an individual into your trust. And so then at my death, my trust doesn't die, right? So my trust is still there. It just says, okay, when Chris dies, the next beneficiary is this person. And so then we're able to avoid that whole ancillary probate process. And then the successor trustee, can just do a deed out of the trust to whomever the next beneficiary is. So really, a lot of times this kind of leads into a bigger discussion about when are trusts necessary, because I get a lot of people that come to me and say, well, Susie Orman says I need to have a revocable trust, or my neighbors have a trust and say I need to have one, draft a trust for me. And so we'll sort of talk through things. And a lot of times we decide this trust isn't necessary, but kind of the things that I look for about when to recommend trust for clients are, one is if they own real estate outside of North Carolina. That's a big one. Two is if we have kind of a heightened need for privacy. So let's say a client has a child that might have drug or alcohol abuse problems. Well, I can plan for that, but I like to do it in a separate trust document, because when I die, my will becomes the public record of the state of North Carolina. So really anybody could go see the terms of my will. And so if I'm going to plug in a lot of kind of sensitive family dynamic issues, or trying to protect a child from their dependency issues, I like to do that separately. That way it can't kind of be seen in the public databases. So out-of-state real estate, heightened need for privacy, or if there's just some other asset that we need to insulate from probate, a small business interest or something like that. I can make the trust the owner of, my shares in XYZ Corporation or something, something like that. That will help me avoid probate with that.
Great. Yeah, well, definitely a lot to think about with every little thing. One other question that's come in, you're hearing a lot recently about digital assets and kind of how that factors into the estate plan. Can you take just a couple minutes to kind of explain what those are and what some strategies are to address those in the estate plan? Yeah,
so digital assets can be difficult. So usually what I'll set up for my clients are, we'll have them do kind of this blanket digital asset authorization form. It's basically just kind of a one-page document that says, when someone is serving as my agent, whether it's my healthcare agent, my executor, or trustee of my trust, I hereby grant them the authority to access any digital account or device, as those terms mean today or as they might evolve in the future. Because it's relatively new under our laws that this is sort of come about. Because what would happen in the past is so there's this, the estate planning section of the bar has a legislative committee that I'm a part of, and in our committee from time to time was trying to introduce legislation that would allow for executors and financial agents to be able to get access to this information. But Google and Facebook, who can afford to have a very strong lobbying force, kept blocking it. And so we couldn't get anything passed. And their rationale, and kind of rightfully so, is they didn't want 50 states adopting 50 different rules. Right. And so finally, the Uniform Laws Commission got together and drafted a uniform set of rules that states have slowly been adopting. And so now really what it comes down to is you can create, there's this hierarchy that you can create. And if you look around in some of the terms and conditions of the different providers, you can see this in there. So you could designate someone as your digital representative for your Gmail account, something like that. But most people don't do that. And so if you don't have a designated agent within the kind of program or the website, then you can have a separate designation document, which would be this digital asset authorization form that I've done. But what I always tell clients is, yes, we've got this form, and yes, it will work if push comes to shove, but I would much rather they be tracking their usernames and passwords in some way, because it's just going to be so much easier for whoever's left to find your password list and get in and get out what they need. I mean, yes, it might be a violation of the terms and conditions of your Apple account, but the Apple or the Google police aren't going to come and get you. You just get in and get out what you need. Right. And there are a couple different ways I think that you can effectively manage that. For some people that don't do a lot online, you can just do a handwritten list, or maybe just a little black address book. The thing that I really like about that handwritten list is it's not like I could hack your computer and get it, right? I would have to physically break into your home, find your list, and then know what it is and be able to utilize it. So the handwritten list is nice if you don't do a lot online. If you're doing a lot, it's going to be tedious to maintain that. So other things that I see people do is maybe have an Excel spreadsheet or a Microsoft Word document that's got those passwords in it. What I kind of tell clients to do is maybe print off that list every year or so and just put it with their estate planning document so it can all be found together. So some people work well with just doing that. What I have moved to, for better or worse, is an online password management system. So it's basically a website that does this for free, but it tracks all my usernames and passwords. So the benefit of that is I really couldn't tell you what any of my passwords are anymore because this system just has them all. They're all random, kind of 8 to 12, characters in length. So I really don't know any of my passwords anymore. So that overall has made me more secure. But the downside is, that's just data that's living on a server somewhere. And so it could be, I'm sure it could be hacked. But that's just the price that I'm willing to pay for the convenience of the system.
Sure.
For brick and mortar banks, it's not that big of a deal, right? If a client forgets their LifeTime asset management password, they can still go to your office and access their information, or I can still go to, the bank and get access to my accounts. It's the people that have Bitcoin or PayPal that has money in it, those ones you really have to have usernames and passwords, and otherwise you're going to be in a tough spot.
For sure. Yeah. We're actually, I think, planning some cybersecurity webinars as part of this series coming up here in the near
that'd be
future.
great.
So we'll be addressing some of those kinds of things.
Yeah.
I think we have time for maybe 2 more quick questions.
Okay.
One that just came in. If I own property out of the country, what do I need to do in my estate plan or in my will?
Yeah. So out of the country is more difficult. Most countries that I find clients commonly have property in, we sort of have tax treaties with them. And so from a tax perspective, it's not overly complex. But a lot of times, the property that's down in Florida that I recommended the revocable trust for might not work in Germany because some countries don't recognize trusts. And so what you really need to do is get an attorney in that country to help you. And a lot of times what we'll wind up doing is we'll have a will that governs my North Carolina and United States assets. And then we'll have a will that's drafted by an attorney in the other country that will handle just the assets in that country. You have to make sure the attorneys are kind of working together and are very careful on how it's drafted, because usually when I draft a will, I say, I hereby revoke all wills that I've previously done.
Right.
Well, if I draft my will here and then a month from now, my attorney in Spain drafts a will that says that, then I'm in a tough spot, right? So you just gotta make sure that the attorneys kind of work together and know what's going on and can accomplish it. So maybe a trust might help with the right system. Maybe a trust is not appropriate because the country doesn't recognize that system. Sometimes you can get away with, maybe my beach house in Barbados, I have now owned jointly with my children. So at my death, it just automatically becomes owned by the children. Sometimes you can get away with something just that easy by doing a deed that way. So there are some things that can be done, but largely it involves employing an attorney in that country.
Yeah, I can see where that would get really complicated really quickly.
Yeah.
One last quick question I think we have time for. Question is, my situation's pretty simple, just a spouse and a couple of kids. Do I really need to spend the time working with a qualified estate planning attorney, or are some of those online legal systems good enough for just getting the basic documents?
Yeah. This is what we call in law school a conflict of interest, right? I'm not going to say you don't need to see an attorney, but really my advice is as you probably imagine is still to see an attorney.
Sure.
I've seen these online legal document providers. I've seen their documents work fine at times, work well at times. And I've been involved in a few estate administrations where it has just been extremely costly and burdensome because mistakes were made as the client had filled out that form. And we had one where a client mistakenly disinherited his spouse. And so,
Wow.
you know, the spouse obviously was not appreciative of that, but it was just an error. I mean, she was named everywhere else as the executor and was guardian and things. It's just, he just didn't click the button to send the spouse first. And then we were involved in another one where a client didn't really have any family, but she had kind of what you're talking about, a pretty simple situation where she was just leaving her assets to charities, to a charity, but unfortunately, she didn't identify the charity correctly. She used kind of an amalgamation of two charities' names.
Oh, wow.
And so we got involved in that and had to initiate an action in Superior Court to kind of let the charities come in and effectively duke it out to see who was going to get it. You know, here I thought they would just sort of split it, but one charity was pretty aggressive and they wound up splitting it 70-30 in the end. But yeah, I mean, it was just a nightmare because it was just a mistake that an attorney would hopefully have caught and known to double check the name of the charity for sure.
Yeah, it certainly seems like there's a lot of really specific little details that you really need to look out for.
Yeah, like you had said, the devil's in the details.
Exactly. Well, thanks for taking a few extra minutes to answer these questions, and thanks to everybody out there that submitted the questions and for engaging with us. If you have any other questions, please don't hesitate to reach out to us. You can reach out to your advisor directly, or you can reach out to us at info@lifetimeasset.com. And just want to remind everybody, we've got some other good seminars coming up here in the next month and a half or so before we get a few more in before the end of the year. The next one coming up in early October is a really good one on continuing care retirement communities. Talk about information about aging in place, retirement options, and more things to consider with that as we all get a little bit older. And then another one that's going to be really timely in mid-October is Medicare and Medicare open enrollment. So obviously there's a lot of different questions that will come up during those sessions for sure.
Yeah.
But again, Chris, wanted to thank you for your time and thanks to everybody for joining in. And we look forward to seeing everybody at the next session. So have a good evening and be careful of the storm out there.
Thank you.
All right. Thanks, Chris. Take care.
Bye.